Hello, I'm Ryan Cook, and this is Civic Tech Chat, a podcast about the civic technology movement. We seek to harness the power technology has to improve the delivery of public services to people everywhere. Emily, thank you so much for joining us here on Civic Tech Chat. Could you introduce yourself and tell us a little bit about what you do?
Sure. Thank you for having me. So my name is Emily Paul. I'm currently a policy analyst at Upturn in Washington, D.C., which is a nonprofit that does research and advocacy around equity and justice issues in technology. And I generally would say I consider myself a critical public interest technologist, and that I'm interested in looking at how technology is designed and used and how that intersects with existing systems and areas that technology is being implemented, and how that affects people's lives, how that can cause harms, and how we can try to challenge that or have technology that actually enhances people's well-being instead of undermining it.
What would you say is your personal why? You know, that thing that drives you to get out of bed each morning and do what you do.
Yeah, so I think sort of continuing on what I was just saying, seeing the role that technology plays in mediating people's access to resources and opportunities, like the role that it plays in distributing those things in our society, and seeing how historically and presently there are a lot of issues with how we distribute resources and opportunities in our society that are much bigger than those technologies, than those technical systems, but that really intertwine with those. And so I guess ultimately my why is to have a more equitable distribution of wealth and power and resources in our society. And sort of based on my background and interests and skill sets, I see technology as one place to look at those issues and to, because of the increasing role that technology is playing in that distribution, to try to unpack what's going on and try to challenge and shift it. The other thing, which I guess is related, but I would say it's part of my why, maybe a subpart, is just wanting to see more collective decision-making about the design and use of technology, and trying to understand what does that actually look like to have more people involved in shaping what technology looks like and how it gets used.
How would you describe the career path you've gone on that's brought you to where you are today?
So I started out in nonprofits doing fundraising and communications work. I didn't have a background in technology. And then at one of the nonprofits I was working at, the New Press, I started learning a lot about social justice issues there. They published the book, The New Jim Crow, and a lot of other important books on criminal justice issues and other social justice issues. And then I also started working on technology project management there and got really interested in how, so in that case, it was a database and a website, how those things were designed and what that meant for how people use them and how that affects people's work or affects how people engage with the organization, which led me to go to grad school in information science. A little bit of a leap, just thinking this seems like an area where I can look at these issues that I'm interested in around how do we organize information, how do we classify things, how do we build systems based on those classifications, and what are the ramifications of doing that, what are the choices that go into that, and again, how could we make those differently potentially in some areas. So bringing together in grad school really that like social justice and technology interest, and seeing how technology is one of the systems and like infrastructures that can really affect these bigger issues that I cared about. And then I actually went to work at Salesforce, and that was an interesting process of kind of seeing what's possible in terms of what I was saying about shaping decisions about how technology is designed and used differently. So I would say coming out of grad school, there was kind of the idea instilled in us, like we'll be in these tech companies and we will just ask these smart questions and we'll we'll bring up privacy issues, or we'll bring up an issue that maybe people weren't thinking about. And then once we did, everyone would realize, oh, we need to think about this. And that was really not how it played out. So I got to see, all the pressures that come from working at a business and the pressures around generating revenue that influence those decisions, and that can cause conflicts when some of these other issues are not aligned. So when like privacy issues are maybe not aligned with increasing sales. So that was kind of an interesting process. I think I had always been interested in going back at some point to some kind of nonprofit or policy work, but seeing that, and then also seeing the role that regulation did play, where when the GDPR came out, how much that influenced decisions that were happening at Salesforce around product design. So I was working as a user experience researcher on a design team, so on a product team building customer service software. And then also at Salesforce, getting involved in some collective action with employees around Salesforce's contract with Customs and Border Protection, and seeing kind of the possibilities of, okay, when it's not just one person in a meeting asking a question, but it's nearly 1,000 people signing on to a letter to the CEO asking questions about how do we think about how our technology is designed and used in an ethical way, in a moral way. And that was a mixed experience, and basically that I think helped propel me to really be interested in doing the Tech Congress Fellowship, which brought me to DC to work in a congressional office for a year. Just seeing how there are these big forces and systemic incentives that really drive what companies that are building technology are doing, and wanting to see, okay, how are those policies actually getting made, and how can those be influenced so that downstream the decisions, being made about what's being built and how it's being deployed might happen differently. So that pretty much brings me to today. I spent last year in a congressional office, in the office of Congressman Mark Takano from California. And then now, continuing to work on equity and justice issues and how technology is designed and built and used here at Upturn.
One of the things I heard in your path seemed to be focused on the situation where maybe like ethics and business concerns don't align. I think it's something I heard in there. Mm-hmm. Are there any like lessons learned that you pulled from being exposed to that conflict that you'd be willing to share?
I think there are maybe more and less cynical lessons. I think for me, I felt like it's really hard to push back against those business incentives when they do conflict with, those ethical concerns or kind of like values, or just concerns about impact of the tools. So I think there's multiple paths to take. Like, I think there's the path of trying to reconcile that and try to, and this is, what is kind of happening in the tech industry right now, like attempting to make a business case for ethics and to integrate ethics into how these companies operate. Personally, I have a lot of doubt about those efforts. Not that I don't think that at the margins, like there can be smaller choices about design that might be ethical, or maybe there can be bigger red lines that organizations decide not to cross. I mean, I think we've seen that happen a lot when employees really push back. So I think for me, the lessons really point to more systemic change, like to more collective decision making. And how do you do that through like more cooperative ownership models and employee board membership, and ways to have the people, I guess, building technology and also the people impacted by it, like actually have decision making power, not just kind of rhetorical strategies. So I don't know if that's what you were getting at. I know that's still maybe a little abstract, but I think for me it like really helped motivate and point me towards like bigger system changes that are, you know, affecting issues, not just affecting kind of the technology ethics conversation.
Are there any pieces of media, be they a podcast, print, video, or something else entirely, that you'd recommend to our listeners out there?
Yeah, I like this question. I think, I mean, you know, there are a lot of, I feel like there's kind of the typical uh, tech newsletters that I definitely find helpful and found helpful last year, keeping up with what's going on, like Politico and Washington Post tech newsletters that come out daily. And then I definitely got very interested in what's happening at the local government level with technology, because there is a lot happening there, and it's much, you know, closer. The sort of decisions being made about it and the impact that it's having are closer there than when you're in Congress talking about technology. So there's New America Foundation, as part of their public interest tech program, has a newsletter called The Commons that is about kind of civic tech and local government projects. And then Route 50, which has a lot of local government and like local, I guess, government innovation stories. And then I also, for kind of the like critical technology angle, would definitely point to Data and Society. They have a podcast of their talks, and they also have a newsletter. The organization I work for has a weekly newsletter that's a digest of tech and social justice news stories that everyone in the organization contributes to. And then maybe we can talk about this more later, but I think for me, like having a bigger political vision and analysis of where the public interest tech work that you're doing fits in is really important to me. So like on the criminal justice side, the book, The New Jim Crow, that I mentioned from the New Press, there's a new book I'm excited to read, and I had the chance to help out with some early research on, called We Keep Us Safe, by the executive director of the Ella Baker Center, which is a racial justice and organization in Oakland. I also have to put a plug, because I love it so much, for Adrienne Marie Brown, her books, Pleasure Activism and Emergent Strategy, and her podcast, How to Survive the End of the World. It's not necessarily technology focused, but just in terms of thinking about how do you think about systems change, and yeah, and just a really, really like interesting, and I always learn a lot from reading or listening to her.
That is an excellent list. I think folks are going to be able to pad out those reading lists and listening lists this year. And worry not, folks. I will endeavor to grab some links to these things and throw them in the description for you, that when you're listening to this in present time should already be there wherever it is you're listening.
That's awesome. Can I add one more thing that a book I'm reading right now that I think actually is relevant to sort of civic tech efforts. So it's called Normal Life, and it's by Dean Spade, and it's about trans rights and thinking about the role of legal reform in trans rights. And I think there are really interesting parallels to thinking about kind of civic tech, and how public interest law and public interest tech are both taking these kind of system, how do I say this? So thinking about the limitations of the tools at your disposal. You know, if you're a lawyer or if you're a technologist, what are the ways that you can contribute to this bigger effort, be it like the fight for trans rights or economic justice or racial justice? And then what are also the places where your toolkit is not actually going to be sufficient or be the right intervention. So that book talks a lot about the idea of administrative violence, and how you know, a lot of these systems that determine eligibility for benefits, that again allocate resources, that is a place where a lot of systemic discrimination and injustice happens, even though it's not necessarily as visible as some of the other forms of discrimination we talk about. So that's another one that I am in the midst of reading and definitely recommend.
As we switch over to our main topic today, which happens to be one that you know quite a bit about, forensic algorithms. For folks that maybe are new to this term, how would you describe the subject at a high level?
Yeah, so, and this was interesting because this was part of the bill drafting process, was figuring out how are we defining the scope of this and defining this term. But generally, forensic algorithms refers to the use of, some kind of automated, semi-automated process in the analysis of evidence for criminal trials or criminal investigations. So the one that was the initial entry point or kind of motivation for the Justice in Forensic Algorithms Act is probabilistic genotyping, which is a form of DNA analysis. But there are other things that fall into this definition of forensic algorithms, like there are gunshot there's systems that can detect, like ShotSpotter is one that can detect and try to pinpoint the location of a gunshot, or tools that are used for extracting and analyzing data on people's smartphones or mobile devices. So broadly, the category is, is an algorithm or software playing some role in the analysis and processing of evidence for a criminal investigation?
A piece mentions that you were inspired to look into this policy area, and that piece was a Slate op-ed type thing called Convicted by Code. What did you learn from that piece, and how did it inform your why for work in this area?
Yeah, that's a good question. And I guess as I think helpful background for something that was interesting to me coming into Congress and seeing, where do ideas come from and how does Congress end up focusing on different things? So this article was written by Rebecca Wexler, who is now a professor at Berkeley Law. And it was a 2015 article about specifically focused on probabilistic genotyping, so that DNA software that I mentioned a minute ago, and how essentially the big motivating thing from that piece was that these tools are primarily proprietary tools, and that consistently when defendants were being charged and ultimately convicted based in some cases only on a match from that software as the evidence against them, when defendants tried to exercise their constitutional rights, so they have the right to confront evidence against them under the Sixth Amendment, they were denied, and they were denied because of the intellectual property rights of the developers of the software. So that was the key point of that article, was that intellectual property rights of the software companies should not be prioritized over or undermining defendants' constitutional rights. And that was something that someone in my office had read back when it came out in 2015 and just felt like very, moved by, and that was just an injustice and that something should be done about it. And then when I came on as a technology fellow, they had the resources and someone who could spend time on that. So that's how we ended up working on it last year. But yeah, so the article really called out that kind of fundamental, even just like procedural injustice, that people's constitutional rights were being undermined or violated, and then also spoke about some specific cases. So kind of, talking about the human impact of this issue.
One of the things I saw in that article is that it uses the term secret code in quotes there to describe software that makes up some of these tools that you were alluding to there in that forensic space. And I think that's a really apt way to describe something proprietary like that, that term secret code. What sort of impact have you seen the presence of and proliferation of that kind of a tool in the criminal justice space?
Yeah, so I think, right, so there's kind of just the procedural injustice part that I was just mentioning, of just this, like conceptually, this is an issue. And then there's, right, how is it actually playing out and impacting people? And that's not totally known, in terms of one big issue with it being secret is that there's not a lot known about how well it works, or whether that's an acceptable, whether these algorithms are acceptable ways to perform this kind of analysis. So I guess there's a few things to highlight. So there's the issue of just furthering asymmetry of power between prosecution and the defense. So if the defendant can't actually adequately confront evidence against them, if they just don't know, how is this software actually working? How is it used in this particular case? They can't kind of surface and question those issues. Whereas if you think about a forensic examiner doing DNA analysis, you can put them on the stand. You can ask, what assumptions did you make when you were doing this analysis? You can kind of probe and surface some of the inevitable subjectivity that goes into any kind of analysis. And that's just not, you can't really do that with proprietary software when you don't have any access to it. And the developers of the software have testified in court generally about the software, but that is not the same thing as, about how is it used specifically in this case. And then to talk about like some other, so there's kind of multiple layers of issues. There's like, is this software, even if it was working perfectly, is this acceptable? Is this the right way for us to be doing this kind of analysis? Is this acceptable for convicting someone, potentially taking away their liberty or even their life? Then there's like, how well does the software work? If we are saying that we think that this software is acceptable, at least in theory, to be used for this purpose. And that's where you get into, again, subjective decisions in how the kind of conceptual method is implemented in the particular software. There's multiple vendors selling this software, and there have been multiple cases where they get different results. And there was one case in New York where one of these probabilistic genotyping tools said, yes, this person is included in the sample. The other said they're not. So you can see how there is some subjectivity. There's some differences in how this is implemented, and it's probabilistic. So like there's a level of error. So there's the question of what's an acceptable rate of error. There's also issues just with bugs in software. And right now there aren't testing requirements. There's really nobody scrutinizing the software except for the developers. And they don't have specific requirements as to what they actually need to do to say this is valid and reliable. So I think there's a lot of questions right now. And this bill honestly isn't, the goal of this bill wasn't to say if this software is good or bad. It was to say we need to be able to look at it. Defendants need to be able to look at it. The police departments and crime labs that are procuring it need to have more information. We, as the public, needs to have more information. We just need to be able to scrutinize this and make a more informed decision about whether this should be used at all. So I don't know if that answered your question. I guess to highlight one kind of interesting story. So New York City, there's the two main tools, proprietary tools. New York City developed their own tool, the forensic statistical tool, and they actually also made intellectual property claims when defendants tried to get access, even though it was developed by a public agency, by the Office of the Chief Medical Examiner of New York. And that tool was really widely used, including other jurisdictions would send samples to New York to run through their software. And finally, in a case a couple years ago, I don't remember the exact year, first the defense got access under a protective order, and then ultimately a judge ruled that the source code itself needed to be released because there was, prevailing public interest in that. And during the defense expert review, they brought someone in, a computer scientist, to review it, and they found, I think, multiple bugs in the code, and also an issue where there was a function in the code that would drop data that would significantly impact the results that was not articulated, like not explicitly acknowledged as being part of how the software worked. So that tool was discontinued, the use of it, after that. But I think that just points out or raises the question, if these tools have been used in thousands of cases, where have they maybe not worked, and we may not even know that?
I think that's a really keen question to ask, because in truth, like some of those things you're bringing up make me feel some internal horror, just because I in my like day-to-day experience building software to like pay the bills,
Mm-hmm.
Bugs are more of an inevitability than a possibility, as far
Mm-hmm.
as I've seen. Like, yeah, you can build things with methodologies that kind of act defensively against those things, and yeah, you can put into place testing frameworks that help you catch problems early or avoid them. But you're really never going to get it 100%, or at least not without some sort of feedback loop feeding you and informing
Mm-hmm.
you, like letting you know. There's a reason why like that platitude of like fail fast is like a popular thing with software people. To hear that there's examples where there were systemic issues that went unknown because you just simply can't peek in to see or to audit. Frankly, that sounds really scary as a human being that lives out in the world.
Yeah. Yeah. I think to your point, like not having a feedback loop, because especially when you think about just, again, that's kind of asymmetry of power that's maybe enhanced by this. And there, like that defendant in California where the results of the software, Martel Chubbs, this was a 2012 case, he took a plea deal. And anyone who, like, when you look at how the criminal justice system works, you see that people often take plea deals when they're innocent. I'm not saying, I don't know in this particular case, but just ostensibly the feedback loop would be, oh, if it's wrong, if it's not working, then you'd find out because you'd realize this person didn't commit the crime. But if the software is producing the evidence against them, and that evidence is DNA evidence is very damning, juries take that really seriously, perhaps more than they should. That's a whole other conversation that people talk about, like the CSI effect, but with forensic evidence. But you don't have that feedback loop. So to your point, and I think the maybe related piece is like there are just no safeguards against the tools entering the system. They're being procured. Crime labs have some requirements around validating tools, but they're being procured, they're being used. The judges who are deciding whether they're admissible or not don't know how the software works. And then the defendant is left as like the last line of challenging it, and they are not really able to do that either. So yeah, I think thinking about how do you have, if anything, this software, this is really high stakes software and should have more scrutiny over it than maybe other tools where an error can be more easily remedied.
I think if I'm hearing you correctly, and I were to try to like draw an analogy to maybe like an analog process
Mm-hmm.
comparison, I guess it's like normally if some forensics happened, say a test was run, you could inquire into like the chain of custody. You could inquire about what methodology did you use to get to your conclusion. You could ask if it was scientifically valid. But in the case of a piece of software like this, where the steps are happening automatically, with the contents of the code being cloudy, there's no way to look into those details to know what those steps were. Am I hearing that accurately?
Yeah, so I think there's yeah, yeah. And I would say, with forensic methods, there's a lot of discussion and concern about forensics in general and about which forensic analysis methods are actually scientifically valid and which are not. So, DNA has a lot more validation behind it than like hair analysis and bite mark analysis, which have been really called into question. But another piece kind of related that you just made me think of is when judges are admitting the results of the software, there are standards for they're evidentiary standards. But the software is basically, I feel like we see this all the time, the software is kind of being treated as neutral or objective. So the prosecution will point to studies that have been done of the underlying method, conceptually the method of probabilistically analyzing DNA samples. And then that's sort of considered, okay, well, it's been validated, but that's not the same thing as testing software. And we don't test software by doing peer-reviewed studies. Like we test software by using it, by testing edge cases, by like really trying to see whether and how we can break it. So I might have just deviated from kind of what you were saying to try to sum it up, but I think that's another like important piece to highlight.
Yeah, I think that's true. That is keen to point out. Is ultimately software about whatever it is about will always carry the biases of whomever designs it. I think that's like a pretty important thing for folks to remember. It's generally not going to be some magical independent arbiter, because humans built it, so it's not going to be less biased than humans.
Yeah. Yeah. And I guess to say, like, if it would be helpful to be a little more concrete about this particular probabilistic genotyping software, and like what some of those decisions, like you're saying, that aren't necessarily being surfaced or able to be traced are. So in typical or like traditional DNA analysis, there's a threshold. You look for peaks at different like alleles, and I'm not an expert in, I learned about this last year, but you look for peaks, and if you see, based on a certain number of peaks, you can like pretty accurately identify, okay, if the peaks appear at these different spots, then that's highly likely that it's this person, and it's, X in one in however many millions or more chance that someone else would have those same peaks. But what probabilistic genotyping does is and in traditional DNA analysis, there's a threshold, and you don't take into account peaks below that threshold because they could be noise. And what probabilistic genotyping does is it doesn't have that threshold. It looks at everything. And the benefit of that is that in more degraded or lower quantity DNA samples, or in DNA samples that have multiple contributors, like more than 2 unknown contributors, traditional DNA analysis, they usually can't get anything from it. It's inconclusive because there's not enough data, or it's low quality, or it's too complicated and noisy, basically, with multiple people's DNA. And the value proposition of probabilistic genotyping is that it can analyze those samples that would have been inconclusive in the past. And so I think there are questions, when there's the risk of amplifying noise and drawing conclusions from it, that is kind of like just, again, these are all just, I'm not able to say whether this is an acceptable method or not. Like, I do not have the correct expertise, but the point is just that people who do need to be like having these conversations and talking about it. And then there's also subjective decisions like, okay, I think that there are 3 contributors here, or I think there are 4, or I think there are 2. And that's a call that's being made by whoever is running the software in that particular instance. And that is going to impact the results. So there are these different places where I think, first of all, at just kind of, again, the like conceptual level of what the software is doing, and then at the level of running it in these individual cases where there are these choices being made, like how much do you amplify these peaks, and what do you consider noise, or what do you take as signal and potential DNA? So all of that is like really important to surface.
And eventually, your work with Representative Takano from California's 41st did lead to a bill titled Justice in Forensic Algorithms Act of 2019. Can you talk to us a little bit about the process you went through of kind of going from finding that problem we've been talking about to then taking the step to trying to get a bill drafted to address it?
Yeah. So like I was saying, when I came in, it was an issue the office had been thinking about for a couple of years after reading that article, and had done a little bit of preliminary research on, but just didn't really have, congressional offices have so much to do. And this is a pretty complex and relatively new issue, and definitely new for Congress. So when I got there, the starting point was so I guess 2 main things: figuring out what should be the scope of this bill. So when we talked about forensic algorithms at the beginning and what falls under that definition, that was a big conversation. Like, is this bill just about probabilistic genotyping? But we also don't want to we want to future-proof it. Like, this should apply more broadly and be more technology agnostic, and not just applying to this one type of tool. So that was a big thing, is to figure out the right scope, and talking to stakeholders. So talking to people, legal aid attorney, defense attorneys, legal aid attorneys who have worked on cases where these programs have been used, talking to people who have tested and reviewed this software in the limited cases where that has happened, academics who are researching this issue. It kind of brought together people who are intellectual property trade secrets people, because that's the defense, or that's the way that the companies were preventing access, was claiming trade secrets, with forensics people, with criminal justice, racial justice people, with algorithmic transparency and algorithmic discrimination people. So talking to all these stakeholders, figuring out the scope, and then figuring out like what how can we both empower individual defendants to be able to challenge this, but also not leave everything up to them, because defendants typically don't have the resources to do that. So how can we also have, that's what ultimately led to this like two-pronged bill, which is access for defendants, but also having a program at NIST, the National Institute of Standards and Technology, to test and report on how these tools work, so that that's a resource that's available, so that every defendant doesn't need to, hire an expert reviewer to look at the source code or to test the software. Some can and hopefully would do that, but also that there would be a report where they would still be able to point to and question some of the assumptions that were made in their analysis. So it was a multiple month process of these conversations, of reading, of trying to see, and trying to connect with people, and trying to also connect with people who maybe are closer to the people who would be mostly impacted by this. So I think that's also a big thing with the stakeholder conversation, is like, who are you including as your stakeholders in these discussions?
I believe you alluded to at least some of this in your answer just before, but if this bill were to be passed in its current form, what sort of impact would you expect it to have? What do you expect it to do?
Yeah. So like I was saying, there are two main prongs of the bill, and one is about ensuring defendants have access to source code and any other information they need to confront and challenge the evidence against them. So that includes an executable version of the software so that they can also run the analysis themselves. That includes this report about how the software was used in their particular case, what inputs were put in, and that they're able, again, if they can afford to and want to, that they could bring someone in to do a review of the software. So that would definitely be one piece, is that individual defendants, the hope is that individual defendants would be able to challenge the results, whether or not they had the resources to do a deeper like source code review, but also that some defendants would take advantage of that, because that could also then, that would have, scaling effects if they did find these issues. If they found issues and they were able to disclose that, other defense attorneys could learn from that. That might impact admissibility decisions in other courts. So that's one big piece. And then the other big piece is the NIST program to test the software and to publicize the results, and to have a process for coming up with what does it mean to test this software. So one thing is, the bill is not actually establishing standards for the software, like it needs to have this accuracy result. The bill, that's a longer conversation, what's an acceptable error rate for software for the criminal justice system, but it's to say, these are the things that you need to test. This is what it means to test the performance of this software, and this is what needs to be made publicly available from the output. So right now, because there's just such little access, there's not much known, and there are many people who are interested in already trying to work on this issue. So the bill would also just open the algorithms up to scrutiny from both individual defendants and from advocates, academics, whoever else wants to try to better understand how it works and raise concerns about how it works.
And I believe the NIST acronym you brought up, is that the National Institute of Standards and Technology?
Yeah.
Okay. So listeners, if you're wondering about that, that is that acronym. And I also had a follow-up about something I heard in there. You mentioned the ability to review the software. Does that go down to the level of being able to try to audit source code, or is it at a different scope than that?
Yeah, no, it does. So the idea is that the bill prevents the makers of the software from using trade secrets to prevent defense access. So they would get access to the source code. It's not directly addressed in the bill whether that would be under a protective order or not, which is kind of a tension in that if it's under a protective order, then only that one defendant can really benefit from the learnings. But anyway, to put that aside, yeah, so they would have access to the source code, but we also wanted to be aware, like, you can't learn everything from source code. And so and also not everyone is going to have, again, that like expert reviewer of the source code. So they should also have their own copy of the version of the software that was used. They should have the performance testing of the software. But yes, I guess to answer your question shortly, it would include that they have access to source code.
And as an additional follow-up there, you mentioned that phrase, protective order.
Mm-hmm.
For folks that don't know what that is, like, what would you describe that as?
Yeah, so that, I mean, in this particular example, and this happened in the very few cases where people have gained access to source code, it's been under protective order. So the judge, like basically the company and the defendant, or the prosecution and the defendant, agree that the defense team will only look at the source code or whatever they're looking at in these. It often can be in a very limited setting, like you can go in a room with a pencil with a printed out copy of the source code, or and it's certainly a prohibition, kind of like an NDA, like you cannot, a non-disclosure agreement, like you cannot share outside of this courtroom or this defense team what you learn from the analysis. So it's just much more restrictive of what you can talk about publicly, what you can disclose. And I'm not a lawyer, but I guess in my simple way, I would liken it to like a non-disclosure agreement.
The last glance I had at the bill tracker for this is that it looked like its status was in something that's called referred to House subcommittee.
Mm-hmm.
For folks that aren't well versed in congressional process, could you tell us what that means, and maybe if you have some knowledge on like maybe what the prospects of that could be for the future then with that status?
Yeah. So every time a bill gets introduced, it gets referred to one or more committees or potentially subcommittees based on which committees would have jurisdiction. So in this bill, in this case, it was referred to two committees. It was referred to the House Committee on Science, Space, and Technology, and it was referred to the House Judiciary Committee. And for House Judiciary, it was referred to the Subcommittee on Courts, Intellectual Property, and the Internet. So you can kind of see between those two committees, you have the IP courts piece and you have the science, like forensic standards piece. And so ideally, the next step would be, so ultimately for the bill to go to the floor, it has to go through committee markup. So that would be the committee making changes to the bill and then deciding that it was ready to go to the floor. That's quite a ways off, I would assume, for this bill. Ideally, a next step would be for one or both of those committees to hold hearings on the issue, because that's where the committee members can learn more about the issue, can start thinking about, what should the bill that ultimately goes to the floor look like. It's very unlikely, or I think maybe completely wouldn't happen, that the bill that was introduced would just go to the floor. So it would go through a lot of changes and deliberations. So a hearing would be kind of the next most obvious step, especially because this is a newer issue that most members of Congress don't know about, and even a lot of the public doesn't know about. So just getting more understanding and bringing in experts and bringing in people to represent, the different sides and stakeholders of the issue. So in terms of prospects, I think there's a few interesting things that, this bill again is like bringing up a conversation that's not happening in Congress. So that takes a long time for that to work its way through the process. But the Science, Space, and Technology Committee did have a hearing last year on forensic standards. So there's kind of the thought that maybe if there's work being done on forensic standards in general, maybe it could incorporate some of the, it should also address software, because where we are now, that's just increasingly playing a role in forensic analysis. And then the other thing that could be interesting is that there will be a GAO report coming out in sometime maybe this year. So that would be another way to get some and GAO is the Government Accountability Office. That would be a way to have some more attention to the issue and some more information about the issue. And that could potentially spur more conversations, in Congress, and also just public conversations or advocacy conversations. So that's a bit of a sense of the process.
Speaking of advocacy conversations, let's say there's a listener out there that's been hearing what you've had to say, is like, oh crap, this is a problem I didn't realize was there. I would like to help push this in some way as a citizen. Is there any way for somebody to do that at this stage, to like highlight the importance of this issue?
I think a huge part of it is having the conversations about it. And for people who do have, like a platform like you with a podcast or a blog or journalism, like having this just be more known, because again, it's still a relatively unknown issue. And part of, introducing the bill last year is that does bring some more attention. And there's certainly people who have been working on this for years, but it's just not necessarily in the common like mainstream awareness. So I think like telling people about it, talking about it on social media, media coverage, like those things all definitely impact what Congress is doing. Not that it automatically will, but that can like raise things to people's attention. I think also it could be something for people to talk about at the local level, because this bill is the federal criminal justice system, but most people who are in the criminal justice system, most people who are being arrested and charged and going to trial, that's not happening at the federal level. That's happening at the state level. And state crime labs or even city crime labs or police departments are the ones mostly buying and using this software. So I think also raising that conversation at the local level or the state level with your elected officials or with groups that are organizing in general around criminal justice or constitutional rights, just like growing. I think we're still at the point where like growing the momentum and the conversation. And because like to your, the way that you reacted as well, I think when people hear, okay, the intellectual property rights are superseding constitutional rights, there's software where there's not a feedback loop, there's not really testing, there are no really safeguards. Like most people react to that and say, oh, that doesn't really make sense, or that doesn't seem fair. So I think just raising awareness feels like kind of the biggest next step. I there's always the like, oh, should you call your congressperson? I don't know if it's at that point. Someone certainly could, and maybe that would cause their Congress member's office to look into the bill, but it's not like this bill is on everyone's minds in Congress. So I think even just getting it more in the public conversation would be a really good next step.
And one of the things that we like to do here on Civic Tech Chat is leave some space on the tail end of our conversation for the guest, in this case yourself, to share with us what you think we should leave the conversation thinking about. So Emily, for you, what are those concluding thoughts that we should take away?
Yeah, I have some, I guess, bigger thoughts. So as I was working on this bill, I was reflecting a lot on, what's the role of, again, being a public interest technologist, working on technology policy, and how to think about that work. And so I guess my thing I'd like to just talk about in the end of our conversation is, because I'm assuming many of your listeners are public interest tech folks or civic tech folks, is thinking critically about our role and the work that we're doing, and having a bigger kind of political analysis and acknowledgement of the bigger conversations that any public interest tech work is happening within or is embedded within. So that's something that I aspired to do with this bill, and I think it's a constant effort to really think about who's in the conversation, like who's providing input to this technology project or to this technology policy effort. Are you having people who are really at the front lines of like these systems of like our legal system, our economic system, and are really experiencing the most kind of harms when technologies are not are either not working correctly or maybe are working correctly but are very harmful. And so I think just thinking about, I feel strongly that no technology work is apolitical. So you always have some politics to your work, and not everyone's is going to be the same. And maybe your politics is overall, I think that this system is working well, and I just want to build a tool that works well and is accurate and works well within that system. I think in this case with criminal justice, our criminal justice system is not working well. It's a very harmful and biased system. It's a racist and classist system. So like that was all animating my work in this. And just thinking about how can you connect your work to these bigger political fights and these bigger like fights for justice that are going on in whatever kind of aspect of our system or whatever domain you're working on a technology or a tech policy project in.
Emily, thank you again for your thoughts, your learning, and your experience. You've pointed out an issue in society I think is very important and very urgent that's impacting real folks' lives. And I'm sure listeners out there are going to get a lot of value of hearing what you've had to say about it today.
Thank you so much for the opportunity to talk about it and for your thoughtful questions.
You can follow us on Twitter using the handle @CivicTechChat. Visit us on the web at civictech.chat, or subscribe to us for content updates wherever it is you download your podcasts.